the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Good day, everyone, and welcome to the Fair Housing Insiders Case Files, Episode 11 with Leslie Tucker, the principal of Williams, Edelstein, and Tucker. I'm your host, Jonathan Sarr. So we have another excellent case that we're going to look at today. So happy to be able to do this with you, Leslie. This case in particular involves the state of New York, specifically their regulation that limits people with serious mental illness from admission to segregated housing or adult homes. So can you explain the basis for this regulation and what was the resulting statement of interest?
Yeah. So, Jonathan, as you mentioned, this case revolves around a specific state regulation that was issued by the New York Department of Health. And essentially, the regulation says that for certain types of housing, which is really transitional adult homes, that's what they're referred to in that state, which are basically long-term care facilities, that are privately owned, not state-owned. But for those particular facilities, if they were of a certain size, so 80 beds or more, then only 25% of their resident population could be designated as those with serious mental illness. So once a facility like that reached 25% of its residents, basically that's its quota, then they could not admit any other individuals, any other applicants with serious mental illness. The reason behind that regulation, the justification for that, is that they say, well, there's been clinical advisories that these types of adult homes are not clinically appropriate settings to provide those types of services to large numbers of residents that have these types of serious mental illness, and that these types of settings don't promote recovery or rehabilitation. So there is, a justification for the regulation. Interestingly enough, the plaintiff in this case is an operator of one of these transitional adult homes. And they say, look, this regulation directly violates the Fair Housing Act. It's asking us as the housing provider to make housing-related decisions based specifically upon someone's disability. And the law tells us that we cannot do that. So it's kind of arguing, look, this regulation is out of sync with the law. So it filed this case against the commissioner of the State Department of Health. So this went and was heard by the state's Supreme Court. And before it was heard, the Department of Justice issued a statement of interest. And the Department of Justice ultimately supports the state's regulation. The Department of Justice has always taken the position that facilities that target certain residents with disabilities creates basically an exclusionary effect. It says that it sort of segregates certain populations within these facilities, making them almost more institutions than anything else. And their position is people with severe mental illness should not be all grouped together in one facility. They should be spread out. They should be integrated within the community. And this regulation helps to do that, to make sure that, this particular group of disabled individuals aren't making up the entire resident population of these adult homes. After it was heard by the Supreme Court in the state, the court ultimately found that the regulation does violate the Fair Housing Act, and that by instituting this 25% quota, it's denying a lot of individuals who have these types of mental disabilities it's denying them their housing choice, and that it's forcing them to kind of go out and find other options when they are no longer permitted to be admitted to these facilities, which might mean a nursing home, which might mean a shelter, places that ultimately are not equipped to deal with their types of disabilities. And denying them that option does violate, on its face, the Fair Housing Act. So it was a really interesting case.
Absolutely. And it sounds complicated too. And I find it intriguing who the plaintiff and who the defendant is in this particular case that you're highlighting for us today. So it leads to a couple of questions, though. So if a housing provider does not provide support services for those with disabilities, and a large number of those applicants are those who have mental disabilities, is there any justification to deny the applicants?
No, there's not. And that's one of the things we learned from this case, that even with the regulation, that the court ultimately shut it down because there really should not be any justification for denying people on the basis of their disability, regardless of whether you offer internal services or not. The idea is that everyone has housing choice, that they live where they are qualified to live and where they want to live. And then services can be set up or brought into them to enable them to be successful in their housing.
Got it. Okay, thank you. So another question for you. So if a housing provider knows that a resident has a serious mental disability, is it required as a reasonable accommodation to arrange for or provide supportive services for that individual?
Is it required? No, it's not. What is required is that you allow them the opportunity to get those outside services that they may need. If you are a type of facility that has a service coordinator or something like that, and that's a service that you provide in-house to reach out to organizations to try to coordinate those types of services, then that would be within, the role of that employee. But no, housing providers in general are not required as a reasonable accommodation to make those arrangements for the tenant themselves. That's really their responsibility.
All right, very good. Well, as always, Leslie, we appreciate your summary of this particular case and some good questions and comments for us to consider. So thank you very much for being on the show again today. Thank you to everyone, our community. Thank you for tuning in. We appreciate your support. This has been episode 11 of the Fair Housing Insiders Case Files. Until next time, take care, everyone.